Thank you very much for the introduction. I'm delighted to be here, and I should say I'm honored also to share the podium with Professor Ogletree. As Professor Hall just mentioned, I spent my career doing largely law and economics work, so that means I'm really strongly within the nothing will work camp, both as a law professor, as an economist. As a law professor, the approach is to say nothing will work. And then, as all of you know, the economics field is called the dismal science. So that's nothing will work plus the dismal science together. And you can gather that you can get the impression right away that much of what I have to do is pessimistic. Also, there's my charge for this symposium. It's my position. It's my job to take the the negative position on this. So you'll have to understand that I'm going to do my job here, which is to give you the questions. Now, that's not the end of the story. As an economist, the major goal that I set out is not so much to give people clear answers on things. And as all of you, as you know, economists very seldom give clear answers to things, and they're always disagreeing about everything. Part of my job is to set up a framework. Part of my job is to think about the issues that need to be considered, and to leave people with a toolbox to use in the future. That's also, I see that as part of my job as a law professor within the law and economics movement or group, I should say, too. Part of the job there is really to set up frameworks for analyzing legal issues, and I don't think the serious people in my field are strongly interested in advancing any conservative position. Certainly there are people who are, but the serious people I don't think are interested in advancing conservative positions. They're really interested in setting up frameworks or tools that will be useful to people who want to study any issue and come up with any answer. So, although it's my job to take the negative position here, my whole approach has been to try to again frame the issues and set up a broader framework for thinking about the whole reparations debate. When I got the invitation to speak at this, the invitation said that we'd be looking into the reparations issue involving lawsuits against private corporations for slavery, and also the issues broadened now. We're also considering claims like the complaint in the Tulsa case as well. So I intend to do both of those. What I'd like to do is start with the more general question about general reparations claims brought for slavery reparations, and then move into a comparison of the Tulsa claim and those kind of claims. So I guess I'm really going to be thinking or talking about two types of reparation claims. One is the Farmer Palin versus Fleet Boston complaint that was filed in New York that many of you have seen covered in the newspaper. The other is the Tulsa complaint that Professor Ogletree just talked about. I'd like to talk about, I'll start with the Fleet Boston case and then move on and compare the Tulsa case to the Fleet Boston case. I wrote a paper. I have a working paper that I've made available to all the symposium participants. It's in the Social Science Research Network electronic library. It's also in the Boston University School of Law's working paper series, which is on their website. And my working paper just looks at the general issues that are generated by the Fleet Boston complaint. For simplicity, I'm just going to refer to this as the Fleet Boston complaint through the rest of my talk. And I made four main points in that working paper, and so what I'll do is just briefly talk about those points and then move in to today's topic, really, which is thinking about the Tulsa complaint in comparison to the Fleet Boston case. The four main points were as follows. First, I wanted to distinguish different types of injury from slavery, and I put them into two groups. One are the obvious, what I call obvious torts, bread and butter torts, things that we all, if you've taken a first-year torts class, you recognize right away. And then other torts that I refer to as social torts, and just to talk about the extent to which we think courts are capable of redressing these different kinds of harm. The second point that I wanted to deal with was the anti-retroactivity principle, And that's really the first defense that people raise in response to the reparations issue. The first, that is, the people who are opposed, the first argument they raise is, well, when slavery was in existence, obviously this was lawful. Since it was lawful, victims of slavery at the time would not have had a claim to bring since it was within the law, and so why should the descendants who are derivatives, whose harms are derivative of those initial harms, why should they also have a valid claim? That's the anti-retroactivity argument. And my paper, which is available, again, the paper that I just mentioned, the working paper, actually disagrees, rejects this familiar anti-retroactivity argument, and I try to make the case that if there is a good argument against the reparations case, it has to be based on different arguments, different claims. The third point that I make in my paper is just to look at the reparations claims as a class of derivative harms, harms that are brought by people who are connected to the direct victims. And I just talk about the extent to which these kind of claims are consistent with traditional tort doctrine. And traditional tort doctrine has been pretty stingy toward derivative claims in general. And so that presents a substantial barrier right there to reparations claims. And the fourth part that I talk about is, the fourth point that I discuss in my paper is the issue of providing information on the gains that slaveholders get from slavery, or people who are connected. And this gets back to the points that were made, the demands that appear in the Fleet-Boston complaint. If you take a look at the Fleet-Boston complaint, it makes demands for compensatory damages, restitutionary damages, and an accounting of gains. So compensatory damages, you're all familiar with, are damages to compensate for injuries. Restitutionary damages are gain-stripping damages, damages that are designed to strip wrongdoers of the gains they get from their bad conduct. And so they don't necessarily have to be designed to compensate someone. It means just simply taking away the illicit profits that were gained from some bad conduct. And then the last demand that appears in this Fleet-Boston complaint is, I consider, a novel one, and that's the demand for an accounting of the gains from slavery. And I make maybe I'll jump to the conclusion, I make the argument that the accounting demand I'm actually quite strongly in favor of. In fact, I would favor a statute that requires, and maybe along the lines of the ordinance in Chicago that Professor Ogletree just talked about, a statute that requires corporations, even families, to disclose, or at least encourages them to disclose information on gains from slavery, and you could actually broaden it and require people to disclose information on information on participation and other claims, other instances that would lead to claims for reparations. For example, the Holocaust, a certain example everyone's familiar with. There's certainly families and corporations here in the U.S. That have records, memories of participation. And these things are bottled up and not brought out into the open. And I would certainly be in favor of a statute that simply encouraged people to bring that stuff out into the open today. And I'll talk about the reasons for that in a few minutes. Again, those 4 points are all related to the working paper that again you can find on the BU website or on the Social Science Research Network electronic library. The first point about the injuries from slavery, I made the distinction between obvious torts, the obvious torts that we see in the case of slavery, torts to direct victims, assault and battery, wrongful confinement, false imprisonment, whichever one of those terms you want to use, and conversion. The 3 of these would certainly be valid claims for someone who's held as a slave today. They certainly form the basis for any restitution claim, because these are all wrongs that would form the basis for claiming that someone's gains from those wrongs should be stripped and given to the people who were the victims of those wrongs. The last claim, the conversion claim, is certainly the basis for a compensation claim, as opposed to restitution, a compensation claim that would be brought today, because the conversion of the surplus labor of slaves created a pool of wealth that the white slaveholders were able to take advantage of and build their wealth on the basis of that. So I'm distinguishing between the injuries that create the basis for a restitution claim and the injuries that create the basis for a compensation claim. The bread and butter torts, assault and battery, wrongful confinement, conversion, there's really not much controversial about that. At least we don't see much controversial. One of the things I talk about in my paper is that if you look back in the literature, you do see that there's some controversy. You do see that the historians have argued different sides on this issue. If you want to begin with just an account of the injuries and the harms, there's probably no better place to begin than Frederick Douglass's autobiography, or at least one of there's more than one version of it, but at least one of the versions of Frederick Douglass's autobiography, which gives several accounts of the brutality of slavery and has served as a primary source for historians for many years of what the regime was like. And then we have later accounts by historians. Kenneth Stamp's book on slavery certainly gives us a lot of information on the harms and the injuries, the torts that were committed during the regime. But then we have in the historical literature other sides. One of the most famous one is a group of economists. Fogel and Ingerman wrote a book, Time on the Cross, that actually tries to downplay the torts, the serious injuries that were committed during the slavery regime, and provide statistics to try to suggest that the account of the harms that one would immediately draw from Frederick Douglass's autobiography, for example, were exaggerated. So this is just to make the point that even this straightforward issue, the one that we would immediately say there shouldn't be any controversy about the harms from slavery, even this issue has been controversial in the historical literature. On the other hand, I think no one would dispute that force, the threat of force, was always a part of the institution, was a major part, was the central, maybe it's an understatement to say it was a major part, it was the central part of the slavery regime. And so in a sense it's kind of a waste of time to debate whether there were many assaults or few assaults, a lot of whippings or not so many whippings that happened in slavery, because we all know that it was the threat of a whipping at any time or an assault and battery that would go unpunished by the state, the threat that this could happen, which was a major reason why the institution could exist. Now, one of the points that I make in my paper is that there were other injuries that I put in the category of social torts, and I named three of them. One of them is the slave marriage. The second is the denial of religious freedom. The third is status deprivation and racism. These were all, in a sense, different kinds of torts. I call them social torts that even today you would have a tough time bringing these kind of claims in the courts and finding that the tort law provides a means of redress. And these, in a sense, I view these as more worrisome problems. I make the analogy in my paper to a virus. These kind of torts are like viruses. In fact, there's a recent book on racism. George Fredrickson's book on racism refers to racism as a virus. And in a sense, these torts have that sort of viral feel to them, in the sense that they're able to be passed on to future generations and create harms that spread and feed on themselves and grow. So, for example, the slave marriage, which allowed the slaveholder to break it up at any time he wanted to because he wants to sell one slave to another place or move them to another place, is obviously damaging to any efforts to maintain a family. And there's some evidence that the bad incentive effects and the damages that were created by the slave marriage were passed on to future generations. There's some suggestion in the evidence, and there's a paper by an economist at Dartmouth, Bruce Sackerdote, I think that's the name, Sacerdote, that looks at the transmission of the harms from slavery across generations. And one of his findings is that the likelihood of being in a female-headed household seems to have been passed on down to generations through the slavery line. So if that's one of the results of one of the social torts, then that's an important damage that it seems that the tort system simply doesn't. I don't see right now the tort system allows someone to gain compensation for that. And it's also true of the other torts that I've mentioned, the denial of religious freedom, status deprivation, and racism. I mentioned racism because slavery was obviously an important feature in giving racism a strong foothold here in America. Slavery gave racism a very important economic function that made it quite useful and made its propagation important to the slaveholding classes. And without that economic function, one would have to imagine that racism would never have gotten quite the following that it got here in this country. The third argument that I go into in my working paper is the retroactivity argument. Again, the first claim that people make in response to the reparations demand is that slavery was within the law when it occurred. So how could someone have a claim based on something that was legal when it happened? And if you look at all of the sources on slavery, even the people who take a fairly apologetic or defensive position toward the slavery regime, they all make a fairly consistent point, which is that slavery seemed to be a system of no law, basically. Slavery was a system in which the slaveholder had cut a deal with the state in which the slaveholder got to define the law on the plantation. The slaveholder himself got to define the law that governed his relationship with the slave. So slavery was a regime in which the state kind of backed out and said, we aren't going to get involved. It's between you, the slaveholder and slaves, to set your own legal regime up. And there's really nothing like that in the history. If you look over the broader arc of legal history, there's really nothing like that. There's really nothing like it anywhere. The closest thing you can find is the family under early Roman history. The father would have had the power to do whatever he wanted to with the children, maybe with the wife too, and without any intervention by the state. But that regime was short-lived. I mean, Roman law started intervening with the father's control of the family pretty quickly. Now, thousands and thousands of years later, now we have a slaveholder who claims to have total control, claims to not have to worry about any kind of intervention whatsoever by the state. And that's a really peculiar. I suppose that's another reason why they call it a peculiar institution. That's a really strange, bizarre institution. There's nothing like it in history, and there's certainly nothing like it during that period of development. And given that, it ought to be viewed as per se unreasonable, per se corrupt, to have a regime in which one private party defines the law in its relationship with another private party. And for that reason, I don't see a reason for respecting the anti-retroactivity argument. It's an argument that says, in effect, that today's law is, in a sense, preempted by a regime that was, in effect, lawless, that allowed slaveholders to create their own law. And so I find that argument, at least on an intuitive, moral, and whatever economic principles you'd like to apply to it, basically indefensible. And so I find myself unwilling to give much credit to that argument against the reparations demand. The third point that I go into in my paper is the talk about slavery claims as derivative harms, and that's where I start to make the nothing will work argument, and that's the point at which I look at traditional tort law, which has been stingy toward derivative claims brought by people who are connected to direct victims. It was only until the 1890s or so, that states started to pass wrongful death statutes. So it's a relatively recent event in the history of the law that we can bring wrongful death claims. You can look through the tort cases and find just a number of cases dealing with derivative harms in which courts have denied claims to derivative harms, and usually these are dealt with under the doctrine of proximate cause in tort law. Though proximate cause is a fairly slippery, elastic concept that appears in different ways in the tort doctrine. And so given that, given the way that the courts have dealt with that concept, the picture simply doesn't look good for reparations claims. And at least the difficult thing is finding a way that a reparations claim could get around that basic principle that comes out in the tort cases, proving causation, proving that there was a direct probabilistic relationship between the harm and the defendant's injury generations after the initial harm. I won't dwell on this point, and I'm sure it will come out later on. I talk about it at some length in the working paper. The final point that I make in my working paper is on the information on gains. That would be that I'm totally in favor of the accounting demand that comes there. Why do I say that? Well, I guess there are two major arguments. One, getting that kind of information, the gains that people get from slavery out in the open is good for two reasons. One, it has the effect of minimizing the current risk of discrimination, the current likelihood of discrimination today and in the future. Why do I say that? Well, because if an institution is sitting on records that show of its involvement in slavery or other discriminatory or oppressive regimes more recently, then it would seem to me that would be a reason within the institution to prevent African Americans from gaining higher positions in the institution and going into positions where they have access to the core of the institution itself, to these private records. So having a history of past discrimination serves as a reason for current discrimination. And so the only reason to prevent that, the only way to prevent that, I think, is by having that kind of information out in the open and not sitting in private records where people can worry about who should be given access and who should be denied access to these things. And the other argument is one that I borrowed this quote from a paper by Jeremy Waldron. I ended up disagreeing with Waldron's argument overall, but it's one quote I certainly liked, and he said that, letting bygones be bygones creates this informational vacuum that's soon filled with the self-serving tales of moral desert by the victors. So in a sense, you need to set the record straight. You need to keep resetting the record straight all along, and that's one important benefit that comes out of having these kind of accounting demands. And that's the reason why I would favor Congress passing a statute that simply encourages this kind of information to be brought out rather than having lawsuits brought asking for an accounting of the profits from slavery. Now, I said that I was going to move to talk about the comparison of the Tulsa complaint with the Fleet Boston complaint. In a sense, they represent two different approaches. This is the time in which I wanted to use one of my tables, keeping with the approach of an economist. I came with charts, of course. So I don't know if anyone knows how to run the screen and can. I'll get to the table in a minute. In a sense, the Tulsa and the Fleet Boston claims have different feels to them, totally different types of claim. One you can think of as basically a justice model, an attempt to do justice in important cases of historical injustice, which the Tulsa case represents. And it's sort of consistent with the traditional corrective justice framework, an effort to sort of right the wrongs, put people back to the extent that you can, back to the position that they were before the injury, to the extent that you can come close to that. And so the approach in the Tulsa case is very consistent with an approach that is at the core of most legal claims. The other approach, the Fleet Boston complaint, which, of course, is of a different nature, is really representative of something I call the social welfare approach, because it's an effort to go for a broad, wholesale redistribution through the reparations approach through the courts. So again, one is an approach that tries to correct discrete cases of historical injustice, correct this relationship between two parties, a wrongdoer and a victim. The other sort of goes broad, seeks broad, population-wide redistribution. Now, these are awfully different approaches, and maybe I should spend a few seconds trying to illustrate the differences between these two approaches. There's nothing controversial at all about the Tulsa approach, which I call just simply trying to do justice. Again, that's the core of every claim. We see it in other complaints that are famous. Professor Ogletree brought up the Tuskegee syphilis case. That was a case that led to a settlement for close to $10 million. The victims were identifiable. The wrongdoers, the government, was identifiable in that case. So there's really nothing controversial about that. I don't see much controversial there in that kind of claim. The Civil Liberties Act of 1988, the act providing compensation for Japanese Americans who were put in internment camps during World War II. Now, that's a case of a legislative action, but again, it deals with a discrete case of injustice, and so it fits in the same model. The Tulsa, the Tuskegee case, the Civil Liberties Act of 1988, all of these sort of fit within the same model. The Fleet Boston complaint, again, is having a sort of broad redistributional goal. It's a very different kind of complaint, and the basis of it, the theory underlying the complaint, is that here's an effort to use the reparations litigation to do something that we know Congress won't do. We know Congress is not, we know the legislature is not going to get serious about these issues. So let's use the courts to do this. So in a sense, the Fleet Boston approach, this sort of broad class action model where the class is a bunch of corporations, successors to firms that had something to do with slavery. The plaintiff class is basically African American descendants of slaves. This broad class-wide approach that we see in the Fleet Boston case is based on the theory that since the legislature won't do it, we better go to the court. And in a sense, it fits the model of the tobacco litigation and now the lawsuits against the gun industry, because the arguments in those cases were that Congress is not going to do anything to regulate tobacco companies. It's not going to do anything more than what we had seen before the lawsuits. And in fact, that seemed to be true. There was the tobacco companies had enough money floating around in the halls of the legislatures to prevent or block any kind of significant change in the regulation of cigarettes. So there's the same argument in this case, that since this is not going to happen through the legislature, we should do it through the courts. Now, I want to say a little bit about that social welfare approach reflected in the Fleet Boston complaint, and then come back and talk about, compare this to the Tulsa complaint. I want to my third chart here. Is that visible? I hope people can see this. Now, again, the basis for the social welfare approach, the Fleet Boston approach. So use my. Oh, thank you. Okay. Oh, yeah. Okay, people can hear me. So the basis for the Fleet Boston complaint is this broad wholesale redistribution. What I've done here is just try to take a look at some comparison of social welfare levels, in a sense, comparing white to black families. We got here families below the poverty line in the United States, and you see that I've got the years 1959, 1969, 79, 89, 1999, and we're looking at the percentage of families below the poverty line, and we see that the percentage for black families, we move from close to 50% in 1959 to roughly 28% in 1969, and then it stays stagnant, almost at that level, for the next 20 years after 1969, then dropping to roughly 22% in 1999. I'm looking at the second column right now. If you look at the first column, that has the same figure for white families, beginning at 15.2%, and then dropping to 7.7%. And then, while it's not showing the same kind of stagnation in the numbers for black families, we come back in 1989 to roughly the same level, 7.8 versus 7.7 in 1969, and then a drop to 7.3 in 1999. Now, we can look at these numbers to get some sense of the upside potential of the redistributional approach that we see in the Fleet Boston complaint. And the numbers don't really present an optimistic picture, because if you look at the numbers between 1969 to 1989 for percentage of black families below the poverty line, it's stagnant. It stays at roughly the same level. And that would have to be considered the most aggressive period of redistributional policies adopted by the federal government. We had the civil rights legislation and the Great Society legislation coming into effect in the mid-1960s. It's unlikely that they had much of an impact by 1969. If they had much of an impact, it would certainly be into those years where the policies were seriously put into effect over the 60s, 70s. And yet we see that the black poverty rate is stagnant during that level. And so this certainly raises a question whether this broad redistributional approach has the power to do much, given that we find that during the periods in which our federal government was doing the most, from what we've seen, we don't see much happening in terms of the poverty rate. One other, admittedly, there are a lot of different ways you can approach this, and this simple analysis doesn't answer the question for good. But this is worrisome to look at this and see and try to draw the implications from this for the policy reflected in the Fleet Boston approach. The other tables look at the percentage of families, married families, below the poverty line, and we see right away a significant drop-off that again, in 1979, the poverty rate falls from 27.8, roughly 28%, down to 13% for black families. We see a significant drop also for white families. The drop-off is certainly a lot larger for black families than for white families. And in fact, I did what economists love to do, which is I played around with the numbers, and I tried to see what would happen to the black poverty rate if you took the same marriage rates that were observed among poor white families, and you applied those same marriage rates to the black families. I won't bore you with the analysis. I'll try to just get to the punchline and tell you the number. I looked for 1999. If you took the same marriage rates that hold among poor white families, and you had those same marriage rates among poor black families, the black poverty rate in 1999 would not be 21.9%. It would be 12.3%. That's the number that I get, and I could certainly go through and tell you the analysis. So what that suggests is a large part of this poverty differential is due to family structure. That certainly presents a fairly pessimistic message for the upside potential of the broad wholesale redistributional approach that we see in the Fleet Boston complaint, because reparations litigation can't do anything about family structure. It can't do anything to change the marriage rate among poor black families. So now, of course, that raises a question. Maybe, in fact, that is the goal. Maybe the goal of the Fleet Boston litigation is to invest in different institutions that create social capital. Maybe the goal is to invest in institutions that foster family stability, business development of skills, things like that. But that's if that's the goal, of course, we have to recognize that there will be a long time between payout and results, and of course that hasn't been suggested at all in the. Can I have the lights back on, because I'll turn this off now. That hasn't been suggested so far in the accounts of the claim. Okay, so maybe that's just a start to point out some of the problems that have to be faced when we take a look at the broader redistributional approach. Oh, thanks a lot. Thank you. The other part of my comparison with the Tulsa and the Fleet Boston complaint is really more of a legal analysis, just to take a look at the different types of claims that we have here. And maybe I should try to cut this off since I see I'm running low on time. I'll try to jump quickly to my next table if I can. What I've tried to do is try to ask myself what's unique about reparations claims, and how can we distinguish the different types of reparations claims in terms of the legal features of these claims. And the two important features that I've pointed out are, one, there's usually a claim of a legal barrier, a credible claim, certainly in many cases a valid claim of a legal barrier that prevented plaintiffs from bringing the lawsuit earlier. So, for example, in the Tulsa case, it certainly seemed unlikely that a claim for compensation brought in 1921 or 1922 around that period would have gotten the plaintiffs anywhere. Or if anything, they would have been lynched by the same mob if they tried to bring that kind of claim at that time. The second issue, the second distinguishing feature is, of course, closely related. That's the passage of time, that all of these reparations claims are usually brought after a long period of time, after the relevant statutes of limitation have passed. And that passage of time feature by itself raises three other legal problems. One is an identification problem of determining who the victims were, who the wrongdoers were, okay, because passage of time certainly makes it difficult to identify people. Now, if we take a look at the Fleet Boston and Tulsa complaints, they're different on that score. In the Tulsa case, we can identify, as Professor Ogletree has pointed out, we have the victims. We can find the victims. We can find some of the wrongdoers. I suppose I haven't read any accounts that suggest that the people who actually did the killing and the burning have been found, identified. But I suppose they're there. I suppose maybe they're living quietly in Tulsa. But certainly the state and local government, to the extent that they were involved in this, they had a hand, either as conspirators or in a passive sense, either as sort of sitting back and watching this happen. They're identifiable, and they're there. So in terms of identification, the Tulsa complaint has the same kind of feel as the Tuskegee case, because there's no trouble finding out who these people were. The passage of time hasn't really affected that. The Fleet Boston case is a different animal under that score, and as other speakers have pointed out today, the identification problem is there in a big way in the Fleet Boston case, because we have these defendants, the Fleet Boston, CSX, a railroad, Aetna, and then there's a reference to 1,000 corporate does, though it could have just as well been 5,000 corporate does, I guess, or maybe 10,000 corporate does. And we're not sure we have all of them there. These are successors to firms that were involved in slavery, so after so much time has passed, these institutions have changed quite a bit. That's a troubling question because there's a background rule in tort law that pretty much says successors aren't, the background default rule is that successors aren't responsible for the torts of the predecessor firm. So given that background rule, that seems to be a pretty serious legal problem right there, just going after successors that are that far distant from the original predecessor firm wrongdoer. So that presents a legal obstacle that we have to worry about. And then we have different levels of involvement. These firms have different levels of involvement. Even if we go back to the predecessor firm, those firms had different levels of involvement. And some of them had very slight involvement, some of them heavily involved, and can a court simply lump them all together and make them pay up for the damages from the period of slavery? There are a lot of the issues are very similar to the market share liability cases, and those cases have been going sort of in a negative direction for plaintiffs. in recent years. The same issues are there when we look at victims. Who should be the victim in this kind of case? Should it only be people who can trace their bloodline through descendants of slaves all the way to slaves? And what do we do about people who can't trace their bloodline all the way through former other descendants of slaves? Are they part of the plaintiff class? Should a billionaire, should Oprah Winfrey be a part of the plaintiff class? So these are questions that I'm sure people have to ask in looking at a case like this, and it isn't obvious right away how you want to answer these questions. The other two issues that come up as a result of the passage of time are causation. I said that we had this passage of time problem, and passage of time itself raises three legal issues: identification, causation, and prescription. That is, the statutes of limitation. I'm using that term interchangeably, prescription or statutes of limitation. These three issues are all connected to the passage of time problem. Tulsa and the Fleet Boston complaints are very different in terms of identification. But then we also have to worry about the proximate cause or causation issues in general, and about the prescription issue. That is, what are we going to say about statutes of limitation? So what I've done, and hopefully I can do this table. I maybe just flash it quickly. Maybe no need to hit the lights, because this table is what happens that table. Here it is. This table I'll just talk about very quickly. Hopefully it's visible. What I've done is I've tried to make a simple framework to talk about these cases in terms of the identification of plaintiffs and defendants. On the columns are talking about whether the defendants are identifiable or non-identifiable defendants. The rows talk about whether the plaintiffs are identifiable or non-identifiable defendants. In Tuskegee, the Japanese internment case, some Holocaust claims. Maybe the Tulsa claim belongs in the case in which all the parties are identifiable, both plaintiffs and defendants, depending on your theory of the Tulsa case. If your theory of the Tulsa case is that it was conspiracy, then of course you would say that the local and state governments were identifiable and belong right there in that first box, because we're talking about active participants on the defendant side and direct victims. I put in the non-identifiable defendants, the Tulsa case, on the theory that they're passively involved, and that maybe this should be considered closer to some of the Holocaust claims brought against, say, corporations who provided technology to the Nazi regime, cases like that, passively involved in the Holocaust. And then the last category, the non-identifiable plaintiff, non-identifiable defendant, is the Fleet Boston claim, and then in the other box I have communal land claims, because those involve identifiable wrongdoers, the United States, government, and non-identifiable victims, the descendants of the original indigenous people who were dispossessed of their land. And in those cases, we have the same issues about identifying victims as we do in the Fleet Boston complaint. So what I've done in the rest of my paper is just talk about the different issues. It seems to me that identification is a really basic prerequisite for a lawsuit. At least in tort law, it comes out as a basic one. We see in a few cases that the tort doctrine has expanded and allowed claims brought in cases where there are non-identifiable ones, victims. But those are fairly special rules, and the question is whether we can expand those rules to the reparations context. I'll stop. I won't go any further to that issue. I'll just let me touch briefly on two more issues, and then I'll sit down and get out of everyone's way. After we pass through the identification issue, which distinguishes, my point is that distinguishes the Tulsa and the Fleet Boston complaints a lot. We have these other hurdles which remain, the causation arguments and the prescription rule argument. Causation argument doesn't seem to be a big issue in the Tulsa case. Of course, it's a big issue in the Fleet Boston case. It doesn't seem to be a big issue. So if you look at both identification and causation, both of them go in favor of plaintiffs in the Tulsa case, which makes me say looks so far like a pretty strong claim. The one issue that we run into where there's an issue in the Tulsa case is just this sort of tiny prescription problem, this problem of, well, what about the statutes of limitation? And I guess to answer that, we need to ask ourselves, why do we have statutes of limitation? Do they serve any good purpose at all? Or are they there just to block these kind of claims and that's it? And sure enough, they do serve good purposes. There's a lot of literature on purposes served by rules of prescription. They bar claims brought when defendants have passed away, witnesses have all disappeared or passed away, evidence is stale. And in that sense, they sort of help courts perform their function, in a sense, by preventing people from bringing claims that are just difficult to resolve and are likely to be erroneously decided, and therefore unlikely to have much of a regulatory impact. So they serve good purposes in general, but in the Tulsa case, we're troubled to see that kind of argument apply. And it seems like a harsh application of the law to bar the Tulsa case on that sort of tiny issue itself. But that seems to be from what I can see of this case, that seems to be the only important issue in the Tulsa case. There's just this little issue about these rules of prescription. Should the statute of limitations be told for the period in which the plaintiffs rationally discounted the likelihood of bringing a successful suit? Seems harsh to do that. On the other hand, I'm not aware of any other court tolling a statute of limitations because the plaintiffs rationally discounted the likely success of bringing a lawsuit. Those are the issues, and then we need to ask ourselves, if we decide these issues in favor of the plaintiffs in the Tulsa case, does that have any implications for cases like Fleet Boston? And I think the cases are sufficiently different that I'm not sure. It's not obvious to me that once we decide everything in favor of the plaintiffs in the Tulsa case, that the Fleet Boston case is that much stronger as a result. That's all I wanted to say. Thanks very much.